Please, Your Lordship, I beg to mention item number 18. Mr. SD is on sanction leave, Your Lordship.
Item number?
18. I'm appearing for the respondent number 1, 2, and 3. And for the petitioner, Lordship. And for the respondent number 4 and 5.
Any objection?
No objection, Lordship.
On prayer made by the respondent 1, 2, and 3. This is matter up to 1 week.
Similar prayer for item number 27, Your Lordship. I'm appearing for the petitioner.
27.
27.
You have 4? Again,
Petitioner.
you have a petitioner.
Yes, Your Lordship.
On prayer made by the petitioner. This is matter up to 2 weeks.
Lordship, Lordship. Your Lordship, I'm mentioning item number 16, Lordship. I pray that this matter may come up after 2 weeks, Lordship.
16 is an old matter.
Lordship.
2016 matter.
Lordship, because we have to seek some instruction, but instruction has not been received yet, so 2 more weeks may be granted, Your Lordship.
On prayer made by petitioner. This is matter up to 2 weeks.
Obliged, Lordship.
Right, please, Your Lordship. That item number 1, that the conducting counsel Ayub Khan, he is out of station, so may come after 2
Item
weeks.
number?
1.
Sorry. No mention in order portion.
Your Lordship. Item number 16. Your Lordship.
16.
Yeah.
Mention has already been made.
May I mention 2 petitions, my lords? I'll be filing them today. My lord, may kindly list it on Monday, as the senior counsel would be traveling.
Fine. Then let us, the registry will do the needful.
They have asked me to mention it, my lord, therefore I'm mentioning.
Fine.
Grateful.
My lord, I beg to mention item number 28, my lord. It's a Nongtrai village matter. It's been pending quite some time, but today not feeling well. So, my lord, if it get taken up after a week or 2.
On prayer made by the petitioner. This is matter after 2 weeks.
2 weeks, my lord. Obliged.
Your Lordship, I beg to mention item number 15, Your Lordship. Let the matter be taken up on Tuesday, Your Lordship. 15.
On prayer made by the petitioner. This is matter after
On Tuesday, Your Lordship.
2 weeks.
May I please, Your Lordship? Item number, I would like to mention item number 29. I pray for 2 weeks' time.
You have 4?
For the petitioner.
On prayer made by the petitioner. This is matter after 3 weeks.
Lordship, I beg to mention item number 20.
My lord, 20 to 26 are analogous matter.
20 to 26,
This is a
Lordship.
school appointment teacher matter, my lord.
I think we were. I think indication is there that this matter will be heard today.
Lordship, the conducting counsel is indisposed, Lordship.
How long?
Lordship, 2 weeks.
On prayer made by the petitioner. Not objected to by respondent. You are for all the petitioners here?
Yes, Lordship.
This is matter after 2 weeks. 20 to 27, no?
26, my lord.
20 to
26.
Obliged, Lordship.
On supplementary course list, item number 1.
This is an application for pre-arrest bail.
Yes.
Lordship, here the related criminal case is the offshoot of a family dispute relating to the inheritance of a ancestral property. Complainant in this case, Your Lordship, is the eldest brother of the named accused who has lodged a complaint on behalf of the previous owner of the property from whom my grandfather has purchased the property and made a gift to me, and my name is situated in the revenue records. No, they wanted to know, my eldest brother, he wanted to grab this property, and for that aim in view, he lost the FIR before the Tura police station. If your lordship just see the FIR, the very nature of the FIR will reveal your lordship that it is not a criminal case, it is purely a civil dispute. Your lordship will see page 14, 1-4. I just read 2-3 para. That I am the authorized person holding a valid authorization letter issued by Srimati Kusum Gupta, wife of so-and-so, to represent Srimati Kusum Gupta in respect of her land owned by her at Garo Hills, Meghalaya, by way of inheritance from her deceased husband, late Shiv Jatan Gupta, situated at Fancy Bazaar, Tura, covered by PP number so-and-so, photocopy of the letter of authority duly authorized and copy of the land patta in the name of Shiv Jatan Gupta are enclosed as Annexure 1 and 2. Your lordship will also notice that when I applied for the certified copy, these annexures which are said to be in the FIR are actually not there with the FIR, because certified copy I have taken on 13/4/2023, and these are not even given, and these are not even forming part of the FIR. That to my knowledge, after the demise of late Shiv Chetan Gupta, the said land had been mutilated in the name of Shri Kusum. Said land has not been mutilated in the name. Even she is not the owner. My name is mutilated, your lordship. So entire dispute, your lordship, relates to the inheritance of the landed property. And
so the land was not in the name of the complainant?
Even not in the name of the complainant, not even in the name of the actual person on whose behalf the complaint is filed. Now they just want to grab this property and pressurize me, and see to the extent of that my eldest brother, he has filed this complaint, with a sole aim. And I have moved to the district and session judge Tura. Quite surprisingly, your lordship, he has rejected my bail application, and I just take 1 or 2 paragraphs of his order. Your lordship will see page 18. Paragraph 3. Heard learned counsel for the petitioner. Lordship got it?
Yes.
Heard learned counsel for the petitioner who prayed for grant of the pre-arrest bail, as the petitioner has been falsely implicated, and that the matter is in the nature of a civil dispute which is to be decided by a civil court of competent jurisdiction. That in the present case, the family member of the petitioner are questioning the petitioner's right, title and interest in the property which he had inherited from his grandfather Leo Diochand Jain Bora. I inherited from my grandfather Leo Diochand Jain Bora, and it is clear that the complainant is questioning this right and title, This is entirely, your lordship, a civil dispute, civil dispute. And lordship will further see, next para, had additional PP Srimati DG Momin present, and after perusal of the CD and IO report, did not show any objection to the grant of pre-bail. Even then, your lordship, learned district judge for the region best known, your lordship, has not thought it desirable.
This order is not impugned.
This order is not impugned, because this is a fresh bail application. And yes, at this stage, your lordship, I will just say.
Yes, Miss Kelly.
Your Lordship, from the records it appears that it is a family dispute for the property, and that there is an allegation against the accused person that he has fraudulently got the property mutated in his name. Be that as it may, Your Lordship, the records may be called for, and then in the meantime, Your Lordship can grant him.
Prima facie,
It's a civil dispute, Your Lordship.
It's totally a civil dispute, Your Lordship.
It's a property dispute which...
that you see, even though the order of the learned district judge has not been impugned,
yes,
but on observation, it is seen that he has
it's a
indeed made that observation.
Yes, it's a property dispute among the family members, Your Lordship.
Heard Mr. B.K. Jindal, learned senior counsel, appearing for the petitioner. Also heard Ms. T. Yangi, learned your AAG, AAG appearing for the state respondent. Mr. General has led this court to the FIR, copy of the FIR, dated 14 March 2023, lodged before the officer in charge, Tura Police Station, West Garu Hills, by one Shri Amit Kumar Jain Bora, against the petitioner herein. On the same being taken on record.
And Your Lordship will find FIR does not reveal any section registration of the case.
Whatever. No, it's not registered.
FIR doesn't say. FIR on the body of the FIR.
Doesn't matter.
The case is registered. Otherwise, why would they be here for
only on the body of the FIR normally it is found.
It is.
I think at the back of the FIR it is there. It is there.
Whatever the case may be,
case is registered. There is no denial.
A case diary has been opened.
Yes,
case diary has been opened and
being Tura PS case number
GD
23-3 of 2023 under section 420 oblique 4. Is it 468 or 486?
68. It should be 68 actually. What is 486?
Certified copy of the FIR is there, Your Lordship, at page.
No, let's forget about the FIR.
Page 13.
It is 468, Your Lordship. At
468.
para 6, it is shown as 468.
Yeah, 4 oblique 471 IPC.
It is forgery. Forgery is 68, not 86.
Petitioner being named in the said FIR has expressed apprehension of imminent arrest in course of investigation, and has accordingly, under the provision of section 438, approached this court with this instant application. Mr. General has, however, fairly submitted that an earlier application for grant of pre-arrest bail was preferred before the Learned District and Sessions Judge, Tura, which was, however, rejected by the order dated 25/4/2023. The said order has, however, not been impugned herein, though copy of the same has been annexed as Annexure 3 to this petition. The Learned Senior Counsel has then led this court to the contents of the FIR to submit that the dispute centers around a landed property situated at Fancy Valley, Tura, which property was inherited. Was it inherited or gifted?
Gifted
Was
by late Diochand Jain.
Gifted to the petitioner by his
Grandfather.
deceased grandfather, late
Diochand Jain.
Diochand
Jain.
Jain. However, the complainant, who is actually the elder brother of the petitioner, has filed the FIR asserting that the said land belonged to one Srimati Kusum Gupta, and on her behalf has filed the FIR alleging perpetration of fraud and cheating by the petitioner as regard the registration of the said land before the authorities. This, in essence, submits the Land Council has the trappings of a civil dispute which ought not to have been brought before a criminal court by such FIR. However, without pursuing the merits of the dispute or the matter in question, for the limited purpose of prayer for grant of pre-arrest bail, the petitioner has therefore prayed for this court for relief thereto. The learned AAG, Ms. Tiangi, on the other hand, has fairly submitted that a perusal of the said FIR would indicate that the subject matter has the nature of a civil dispute, but has, however, made a prayer for production of the CD of the case diary to enable this court to ascertain the extent of investigation therein. Next, this court, after giving due consideration to the submission made, and taking note of the contents of the said FIR, would agree with the parties that prima facie it does appear to be a case of civil dispute for which the parties have an alternative remedy to take recourse to, be that as it may. Since the petitioner has expressed apprehension as far as arrest is concerned, the court would consider such apprehension, and in the light of what has been stipulated under section 438 CRPC, and by noting a catenary of judgment passed in this regard, where in such case the court is called upon to consider certain guidelines, parameters and factors relating to grant or non-grant of prayer for pre-arrest bail, one authority of which may be the case of Siddharam Satlingappa Mehtri versus State of Maharashtra 2011 1 SEC 694, particularly paragraph 112, wherein a set of parameters or factors have been laid down for consideration by courts dealing with matters of pre-arrest bail. Consideration which consists of the nature and gravity of the situation, the antecedent of the petitioner, and the like. In view of the above, this court is of the opinion that this is a fit case for grant of pre-arrest bail to the petitioner. Accordingly, in the event of his arrest, the petitioner is directed to be released forthwith on condition that on the following condition: that he shall not abscond or tamper with the evidence and witnesses, that he shall present himself before the investigating authority or the court concerned as and when required, that he shall not leave the jurisdiction of India without prior permission of the IO, and that he should also and that he shall produce a personal bond of 50,000 rupees along with 2 sureties of like amount to the satisfaction of the arresting authority or the court concerned. Accordingly, this matter is now hereby disposed. No cause.
Lordship, permission of IO is very much against, maybe kept as court without the permission of the concerned court.
Oh, the IO is in charge of the case. You cannot bypass his authority.
No, definitely. Supposing normally he doesn't say.
If he doesn't give you permission, you come before this court or you go before the court.
Highly obliged.
Yes, miss.
May it please your lordship. Your lordship, this
What are your instructions then?
The matter was heard yesterday, lordship, to a certain extent, and I have received instructions and also through WhatsApp, lordship, whereby the statement of the bail applicant was recorded on the 25th, lordship. So it was just on Monday, lordship. And this is because the accused person had appeared before the IO. Lordship, I beg to submit that...
Copy of the...
Lordship, prior to that, lordship, I beg to submit that there was no direction from this honourable court while granting interim bail for him to appear before the IO. The only condition was to cooperate with the investigating agency, lordship.
That would include appearing before the IO.
Lordship, what I mean to say is that on the strength of the interim bail, lordship, he had evaded arrest for 4 months and a half. But only because of the interim bail he has appeared, so that in the hope that maybe anticipatory bail would be granted, Lordship.
Yesterday, the submission from my learned senior GO was that I have not cooperated, despite having the interim protection of.
I think you are very mistaken. You cannot make such a submission because that was prior to applying of bail. Lordship, this was prior to applying of, after applying for bail. He cannot say that I made a submission before this honorable court that didn't cooperate. Lordship, the instructions that came was after the bail application was filed, Lordship. He did not clear that file. So you cannot make such a submission.
That is why the court has passed the order.
Yes.
Pass what order?
Let me go to the If I recall correctly, you said that some seizures were made from his residence.
Lordship.
Were they confirmed to be stolen property or otherwise?
I'll take your Lordship to the CD, my Lord. Lordship, I beg to read out from the statement of Siddiqui Ali, who is the father of the accused, Lordship. His statement before the police is so-and-so the so-and-so applicant had pleaded with him to meet with the complainant of the case to request to withdraw the case as he's tired of running away from the police arrest. That's obvious also from the statement, Lordship. My son handed over to me cash and jewelry which he had stolen in the commission of the crime. As I was very curious to meet Muzaffar, but I was waiting for the right time to meet him and kept the stolen property as an admitted fact, Lordship, by the father of the accused that it is stolen property, Lordship. And Lordship, I also beg to submit, Lordship, as I had submitted yesterday, that the accused person, the bail applicant herein, he's a habitual offender, Lordship. Lordship, I beg to state that having gone through the statement of the accused, he has admitted that he has been absconding. He even went to Assam also to evade police arrest, Lordship. And I beg to state, Lordship, that the grant of interim bail and also the grant of regular bail, Lordship, they are two different aspects together and it should not be taken into consideration, Lordship.
That is always there.
Lordship.
Interim bail is only to allow the party some breathing space when the records are called for or otherwise.
Lordship. And I also beg to submit, Lordship, that this is a crime against society. There was no personal enmity. They are unknown to each other, the complainant and the accused person. This is a crime. This is a crime against society, Lordship. This is a second offence recorded. Other offences we are not aware of, Lordship, but as per my instructions, this is a second case against the accused person, Lordship. All of 21 years of age.
May I make submission, Lordship? So far as the seizure, Lordship, in the FIR, the informant stated that jewelry amounting to ₹10,000 has been looted from my residence, Lordship. Police have seized 5 numbers of ring from the possession of my father. So far as, Lordship, the case which my learned friend is referring that I am having another case, Lordship, that is 411, Lordship, regard to
receiving of stolen material, my lord.
That I purchased one phone, Lordship, from Mr. X. When I was summoned, then I pointed that I have purchased the mobile phone from Mr. X. Then police have arrested Mr. X and the case is proceeding against him. Now, Lordship, if I have a case pending against, same case pending against me, the police would have the IO would have arrested on the same day in connection to that case, Lordship. Because IO is very much aware that I was having another case against me. So
That's Haliday-Ganj case, Lordship. I don't think there's any relevance here.
that with regard to the seizure, the informant has said that looted amounting, the jewelries amounting to rupees 10,000. So we do respect the conduct of the IO, Lordship. Though IO, I am not making any comment against him since he is the IO. Inadvertently or whatever reasons, he ought to have updated that I have appeared in the appeared before the IO. He would have mentioned in the CD. Inadvertently or whatever may be the reasons, he has not what you call my statement, or it was not updated in the CD, Lordship. So I am not making any allegation against the IO, Lordship. Maybe some other reasons also. What happened? I obtained the order on 28th, Lordship. Then 21st, Lordship, I have sent the order, Lordship. Then 22nd was the Eid, Lordship. On the very following day, Lordship, I have went to the Thana, communicated the order. Then 25th, I was summoned. I came along with my father, as well as the one village elder, that is called secretary of the village defense party, Lordship. So I have cooperated. My only prayer is that, Lordship, since I have been cooperating, Lordship, and I am ready to cooperate, Lordship. So in the event if the case charge sheet, Lordship, I am ready to face the trial, Lordship. At this stage, my young age, Lordship. So my interim bail may be made absolute, Lordship.
If I may, Lordship. Lordship, he made certain allegations against the IO of the case, Lordship. CD was received, Lordship, immediately when it was called for, Lordship, prior to the appearance of the accused person before the IO. Lordship, the case diary was already in the custody of the public prosecutor, Lordship. As such, having practiced for so many years to make such allegation, being aware of what is going on, he can cast aspersions on the IO, Lordship. With these grounds, Lordship, I strongly object to the bail application.
But Mr. S.A. Sheikh, learned counsel appearing for the petitioner. Also heard Ms. Anjishela, learned senior GA appearing for the state respondent. The case of the petitioner is that an FIR was filed by one who is the complainant here?
Mofuzul Haq, Lordship.
This FIR was filed by
Mofuzul, Mofuzul.
Yes, yes. Your type copy says son of
Lordship,
also.
Lordship, that name is gone missing, Lordship. Yeah. Because when I got the FIR, Lordship, because that was illegible, could not read, Lordship. Subsequently, I asked for the FIR, Lordship. Mofizul in the original copy.
Mofizul.
Mofizul.
Yes, Mofizul.
Below down.
Yes. Kunum to Mofizul Haq. An allegation was made that a group of 7 dacoits broke into his house and tied his hands and feet with cloth, and thereafter had looted gold and silver ornaments from his residence and also from his shop, which includes cash amounting to rupees 1,60,000. On receipt of the said FIR, the police had registered a case being, what is the case?
48 within bracket 6 Lordship, Pulvari PSA.
Pulvari PS case number 48-6 of 2022 under section 397/395/34 CIPC. In course of investigation, in course of investigation, a number of persons were arrested.
2 Lordship, 2 persons were arrested.
Two persons were arrested, and
one is my driver.
On this statement of one of the accused, it was revealed that the vehicle said to have been used for the commission of the crime belonged to the petitioner herein. It is also said that the said arrested accused had implicated the petitioner herein as being part of the commission of the said crime. Accordingly, the police were on the lookout for the petitioner in order to arrest him in connection with the said case. Next, apprehending arrest, the petitioner has approached this court for grant of, with a prayer for grant of pre-arrest bail under section 438 CRPC. It may be stated that on this matter being placed before this court by order, this court by order dated
18th Lordship interim order.
Okay. Order dated 18/4/2023 has allowed the petitioner to go on interim bail. Pending production of the CD of the case diary before this court. Today, when the matter is finally heard and the case diary duly produced before this court, the learned counsel for the petitioner has reiterated that the petitioner is not at all involved in the alleged crime, and that he admittedly is the owner of the vehicle said to have been used in the commission of the said crime, but such vehicle was in the custody of his driver. And as such, not being in control of the activities of the said driver, he cannot be implicated in the said case. Another argument advanced by the learned counsel for the petitioner is that the petitioner is a young person, and if arrested, his reputation and future will be in jeopardy. It is further submitted that after this court had granted the interim bail, the petitioner had accordingly approached the concerned investigating officer, and his statement was duly recorded under section 161 CRPC, and as such, having cooperated with the investigating authority, this is a fit case for grant of pre-arrest bail. Per contra, Ms. Angie Shilal, Senior GA, has strongly opposed the prayer made for grant of pre-arrest bail by submitting that from the contents of the case diary duly produced before this court, firstly, the complicity of the petitioner in the commission of the crime has been made out when, in course of investigation, the IO had questioned the father of the petitioner, who has clearly stated that he was in the know that the petitioner was in possession of the stolen property, and that the said stolen property was also seized from the house of the petitioner, who was staying with his father at the relevant point of time. Another contention made by the learned Senior GA is that the petitioner has a history of that petitioner's antecedent reveals that he was also involved in a criminal proceeding concerning possession of stolen goods, and as such, in the light of this fact, it would not be just and proper for the petitioner to be enlarged on bail at this stage, or for that matter for the interim bail to be made absolute. Next, this court has given due consideration to the submission made. A perusal of the said FIR would show that the allegations are indeed serious, inasmuch as the offence of dacoity and robbery was alleged against the petitioner, and the other accused, coupled with the fact that certain seizure was made, which in due course may turn out to be a part of the stolen property. Therefore, in the light of well settled principles of bail jurisprudence, and also in view of authoritative decision pronounced by the Apex Court and other high courts in this regard, reference to one of them being the case of this court even though this court, even considering the fact that the petitioner has cooperated with the IO by his statement being recorded, is of the opinion that the investigation, the IO has to be given more time and a long rope to complete his investigation so as to get to the bottom of the matter. The custodial detention of the petitioner at this stage may be necessary. In view thereof, this petition is found to be devoid of merit. The same is hereby dismiss. The interim bail granted is discharged, and the IO is directed to take necessary steps in this regard. Registry is directed to, in view of the fact that the Leonard Senior GA has handed over the CD at the bar, the same is the courtmaster is directed to return the same immediately. Petition disposed of, no cause.
Much obliged.
You can try, see. Let's see how it goes. First you cooperate with the IO and then the authority.
Much obliged, my lord.
Really costless. Item number 1.
I know.
Lordship, Mr. A. Khan is appearing in this matter, Lordship. There is an application for condemnation of delay, Lordship. So he is not available today, Lordship. I am not.
Oh, you are not in the case?
Because this is filed by through the insurance, Lordship.
Where is Mr. Khan?
He is not available, Lordship. He is some personal difficulties, Lordship.
Submission has been made on behalf of the Learned Counsel appearing for the petitioner, for the applicant, who is said to be indisposed. On pre-made, this is matter of the... How long?
3 weeks, my lord.
Why 3 weeks?
Because I'm out of station next week, my lord.
3 weeks.
Obliged.
May it please your lordship.
Yes, Mr. Shulai.
Lordship, item number 2 and 3, and then another item in the hearing that is item 30. These are analogous matter, Your Lordship.
Connected matter, my lord. Connected. This
So we'll
relates
take
to
it.
482.
So we'll take it up at the hearing.
At the hearing, my lord, another AG also not that keeping well.
This
I
matter
don't
can
want to
be
press
taken
today.
after
You had
2 weeks. I had
you
an
had a fight?
accidental cut yesterday at home, Your
Oh,
Lordship. I got 8 stitches.
I thought you had a fight with somebody.
I think that is not the age
At
anymore.
at your
Your
age, I don't think it's proper. Yes, please.
After 10 days, we'll do or 2 weeks, Your Lordship.
So this matter will be posted for hearing.
For hearing, Your Lordship, yes.
Parties have submitted that this matter is connected.
Item number 30,
with
Your Lordship.
Similarly,
2, 3, and 30, Your Lordship. That is
with similar matters
number 64 of
being
2022.
with similar matter being case number.
Lordship, that is in the hearing, criminal petition number 64 of 2022.
Item number.
Last item, Your Lordship. Last item. Last item, Your Lordship.
With criminal petition number 62 of 2022.
64, Your
Sorry,
Lordship.
64
of 22.
2022. And as such, the parties have submitted that this matter may be
Heard finally, Your Lordship.
together.
Yes.
On premium, list this matter for hearing after 2 weeks.
Lordship. Highly applied, Your Lordship.
Yes, Mr. Butsanji.
Whether they would like to file.
Excuse me.
Lordship, I am for the respondent number 3, 4, and 5 under the instruction of Ms. P. Bhattacharjee.
But have you filed your counter? Have you filed your counter affidavit?
No, Lordship. We need 2 weeks time, Lordship.
Are you going to file your rejoinder? Or?
Your Lordship, we have to take instruction. Your Lordship, we have to go through the affidavit, Your Lordship. Whether we have
Mr. K.P. Bhattacharjee, Leonard G.A., appearing for respondent 1 and 2, has submitted that the counter affidavit on behalf of the said respondents have been filed. However, Leonard Counsel for the respondent 3, 4, and 5, respectively, as well as the petition, Leonard Counsel for the petitioner has sought for, Ashoka to respondent 3 has submitted that some time may be allowed for the petitioner, for the respondent to file their counter affidavit if so advised. The petitioner, on the other hand, has submitted that some more time may be allowed for the rejoinder, if any, to be filed. On premium, this is matter after 2 weeks.
Very obliged.
Item number 5.
My lord, it is a part-heard matter. Today, already CGC and Mr. KP will give a report.
You will be appearing for?
I'm for the only for Assam bill.
Assam Rifle. Assam Rifle.
Yes, yes.
Oh, Mr. Sinkon is for?
Assam Rifle Public School.
For the school.
So
Assam Rifle and school are different. I think. Yes.
So
And the state has yet to make its submission.
So here in this case, in this matters.
What is the allegation against this Assam Rifle?
So
what are your vermins made against the Assam Rifle?
Assam Rifle, my lord.
In your pleadings?
My lord, they are controlling the school, management of the school.
So,
okay.
Yes.
So you will see here, in this all the writ petitions. Some writ petition is there for their transfer, and some others aspect of the matter about the amalgamation of the society. So you will see in this case, on behalf of this Union of India, my stand is here, you will see, that there is no elements of this. There's any fund given from the consolidated fund of India. No fund is here given. And only the matter is there, you will see, the Assam Rifle Public School is situated within the premises of the Assam Rifle. This is.
You have filed your affidavit.
So you will see, affidavit is not filed. But
you have not filed affidavit.
So in this case, you will see here, our stand is there only. We are not necessary party in this case, because the school is run by the society.
Mr. Depnar, if you have not filed your affidavit, means you have no, there is no pleading on your behalf.
But there is no relief has been asked by the petitioner against us, and only the mere submission.
No relief has been asked against you?
No.
But it has been alleged that you are the sponsoring body of the school.
So here no record is produced as such to give a reply by us that this is the reply will be required. Merely saying, without any documents, then there is no need to file even the affidavit. If they ask any relief against us, then we could have. So they are saying alleged, and then this has been clarified that when this school was in trouble, finance constraint was going on, and they are not in a position to bear the expenses of the salary of the teachers, then from the welfare fund of the Juans, they have given some fund. This is different. It is not connected with the consolidated fund. So when this petitioner is not asking any relief, and no relief could be granted even by the Union of India in the matter of the school itself, so we should not be a necessary party in this case. And since beginning we have taken the same step. So due to this, we didn't file any affidavit in this matters. Even when this petitioner argued the matters, not substantiate any matters that any fund is given from the consolidated fund of India or the Assam Rifle. Even when this argued by the Assam Public School, they also not produce any documents that any fund has received from the Government of India, and it is pervasive control of the Union of India. Neither the petitioner or the respondent is Assam Public School. So in such situation, no relief has been sought against this Union of India, and in such situation, we will not be necessary party in this case, and our name may be deleted in the error of the parties. So this is my submission.
Yes, Mr. Bhattacharjee.
My lord, most of the things, my lord, my friend has already covered. Whether with regard to the, my lord, what is the locus of the petitioner. So nevertheless, my lord.
See, there are few clarification you have to make.
My lord.
Number one is when the approval was accorded.
My lord.
Was it done according to rules or according to the provisions of the law?
Lord, in our affidavit, we have stated that it is done as per rules. Now, Lord, assuming, my Lord, there is a situation that the rule has not been followed. My Lord, that being so, my Lord, who has the right to challenge? Definitely not the petitioner. My Lord, the intent of the rule was that, my Lord, it was the power is given to the members. If any objection is there, it is for the members to challenge, not for the petitioner. My Lord, on the other day, petitioner argued that there is certain conditions which affect, my Lord, the service condition of the petitioner. That's why, and therefore he can challenge the whole amalgamation.
So
No,
that
it
gives him
cannot.
the locus.
No, that does not, my Lord. He cannot
That
challenge
is his
the
contention.
My response, my Lord, is that he cannot challenge the amalgamation. At best, my Lord, the petitioner can, my Lord, pray for striking out of, my Lord, certain conditions, my Lord, going by his submissions, that this condition is affecting us. He may challenge this point. But other than that, my Lord, he cannot say that just because that certain condition stipulated, my Lord, a new condition has been brought about in an amalgamation, he cannot say that I will challenge the whole amalgamation. That cannot be so.
So the process of amalgamation, according to you, cannot be challenged.
Yes, my Lord.
But the condition leading to the amalgamation may be
at best, my Lord. At best,
challenge. Yes.
If something is prejudices the petitioners, okay, maybe that is another aspect, my Lord. But challenging the whole amalgamation, the petitioner does not have any authority, my Lord. Where is his locus, my Lord? That is exactly why, my Lord, if I am allowed to take, my Lord, to the rules, my Lord. So I will take, my Lord, to sub rule, section 12, my Lord, section 12, subclause 3, my Lord, of the
Registration Act.
Of the Registration Act, my Lord.
Meghalaya, we have a separate.
Meghalaya, my Lord. Meghalaya, my friend has also.
Meghalaya.
Those compilation.
Page number 415, my Lord, it is available.
Compilation, in which case you have.
My Lord, my submission is with regard to, my Lord, WPC 217 of 2017.
217? 217. Your compilation is not compilation.
My Lord, this compilation was submitted, but my Lord may take the Meghalaya Act also, my Lord.
Yes. The Act is here. Tell me.
My Lord, for my Lord's convenience, I may be allowed to read the whole section, my Lord.
Just a moment. You're reading?
My Lord, I may take my Lord's attention to section 12 of the, my Lord, Meghalaya Societies Registration Act 1983.
Yes.
Small for convenience, my Lord, if I am allowed to read the whole section.
Please.
Section 12, subsection 1. Whatever two or more societies desire to amalgamate, the governing body of each society shall submit the proposal in writing to the member thereof, and such proposal shall be considered in a general meeting of the society convened for the purpose. No such proposal shall have any effect unless, my lord, these are so and so conditions, my lord. So now our stand is that all the conditions have been followed. Now even assuming, my lord, whether the petitioner has any right, no. My lord, we'll come to, my lord, the subsection 3, what it says. Now even let's assume, my lord, a situation where the proposal was rejected, not accepted. And who has the authority to challenge it, my lord? It says 3. An appeal shall lie to the state government against any order of registrar refusing to accord his approval to the proposal or to his suggestions for any modification, and the decision of the state government on such appeal shall be final. On the proposal being confirmed, the amalgamated society shall be registered under its new name. So, my lord, here in this situation, my lord, there was no, my lord, tussle between any of the societies, either the previous society or the new society or the amalgamation. Admitted fact that everyone is agreed. Now, procedure, my lord, it's at times procedure is, my lord, it is just procedure, my lord. But where there is no objection on either side, my lord, if objections come from no corner, then I don't think there is any impediment in granting approval, my lord.
But would that be a license for any irregularity to be, to be committed?
No, my lord, even that being the situation, if such a thing has happened, my lord, whether the petitioners have the right, no, my lord, they do not have. Only the members can challenge. He is an outsider, he cannot challenge. Who is going to be affected? My lord, if certain conditions are violated, who is going to be affected? It is the members who are going to be affected. Any aggrieved members, they have the right to challenge. Petitioner is just an employee of a certain organization. He has no right, he is not a member. No right has been given to him to challenge. So primarily my submission is this, my lord, whether the petition has the locus to challenge this amalgamation, no, he does not have the locus. Most of it, my lord, my friend has already covered. So this is the stand of the state also. In our affidavit also we have stated that whatever is done is as per procedure and there is no violation anywhere. Now even assuming, so I am coming to that again, my lord. So this will be my submission overall. So my lord, even coming to that, if we go by what the petitioner is saying, that rules have not been followed, etc., etc., even then he has no authority or no right to challenge it. So now my basic submission is this, my lord. So
that is the only point you have to address.
My lord.
My lord, I be allowed to give a reply to argument advanced by 3 learned counsel. First, with regard to Mr. Singon, my friend, earlier occasion, he had argued that the judgment delivered by this court and upheld by the Honorable Apex Court earlier is not binding to this Honorable Court. Because he said there is exception in the principle of res judicata. And 2 exceptions are there. He cited that judgment. I'll clarify. And second one, he said with amalgamation was done in due process of law. And with amalgamation, like Mr. KP, my friend, if there is any error in amalgamation process, along with registrar, I have no locus to challenge. Now, with regard to transfer has been done for larger interest of the school, education purpose of the school, and it is part of the contract of service. Therefore, I cannot challenge it. This is the submission given by my friend earlier. Now, with regard to the jurisdiction issue, my lord, it is already decided already. He cannot be allowed to open. To that effect, my friend has cited this Canara Bank versus NG Subia Shetty and others. The 2018 matter, whereby the Justice RF Nariman spell out the two conditions of non-application of res judicata. Now, in that case, what happened? Respondent number one availed a credit facility from the Canara Bank, and he was unable to repay it. Default was there. Therefore, Canara Bank has instituted an application before the Debt Recovery Tribunal, Bangalore, in 2001 for recovery of 52 lakh something. Now, during that pendency, what happened in that case? The agreement was ended between the loanee and the bank called assignment deed. Because of the illegible. Assignment deed, whereby the respondent allow the bank to utilize his the patent rights and collect royalty from his company. Thereafter, what happened, my lord? The bank has cancelled that assignment deed, saying that we receive instruction from the higher authorities that the bank cannot generate interest or income apart from banking business. It was cancelled, my lord. Agree with that, my lord. The respondent, private respondent, has instituted a suit against the bank to protect that assignment deed, as well as recovery of a certain amount, 17 lakh something. And also, in the meantime, my lord, the bank also instituted a suit to declare that assignment deed executed by the chief manager of the bank can be declared as a nullity, arrive as by fraud and misrepresentation of facts. So these two cases were taken up, suits were taken up by the trial court, and the suit was decreed. Pass of a final order. With regard to the suit filed by the respondent number one there, a private citizen, the court say that the cancellation of the
Why don't you have a glass? Why don't you have a glass of water?
Because of the allergy.
Yeah, that is always there.
Well,
at least your colleague can offer you some water. Yes, please continue.
So, because of that matter, the assignment deed cancelled by the bank is illegal. So assignment deed survive. And with regard to the, however, recovery of 17 lakhs from the bank was denied by the trial court. And with regard to the suit filed by the bank, the trial court has dismissed it. Now, against that two common orders, my lord, in the common suits, the private citizen respondent number one filed a review petition. And review petition was allowed. Against that allowing review application, the bank filed appeal. And appeal was pending before the High Court. In the meantime, my lord, on the basis of the trial court order saying that the assignment deed is revived, you cannot cancel it. On that basis, my lord, the private citizen respondent number one filed a fresh suit against the bank for recovery of 12 lakhs and to declare that to recovery of 12 lakhs something. Now that suit was contested by the bank, and they went contesting by before the trial court. The trial court said that no, principle of res judicata applied because there is an earlier suit filed by you and filed by the others. Court has already declared that assignment deed is permissible. So the bank took the plea that no, that assignment deed was illegal. It was prohibited by the Banking Regulation Act 1949. So that principle of res judicata is not applicable. Civil court rejected that contention, passed a decree, and the matter went to appeal. High Court, Honorable High Court passed the same, dismissed the appeal, said that the res judicata applied, and the matter reached the Supreme Court. And there, my Lord, Apex Court held that when there is a statutory prohibition under the Banking Regulation Act, that the bank cannot generate any interest or income apart from banking business. You cannot collect royalties or others. That legal prohibition is there. So once that legal prohibition is there, no matter that, my Lord, the earlier suit, the trial court has passed that order, res judicata is not applicable because of the legal prohibition. So this is one of the exceptions of the res judicata, my Lord. Second is, my Lord, with regard to jurisdiction, the Honorable Apex Court spell out again that, for example, the trial court, my lord, trial court pass a sentence and send the accused person to a jail. For example, the civil court, my lord, with the same fact of the case, parties, the matter came up before the magistrate court. The party cannot rely, Supreme Court says, on the order passed by the civil court that the principle of res judicata is applicable. The Honorable Apex Court said that the order passed by the civil court in the criminal matter, there is an inherent lack of jurisdiction. So therefore, the order passed by the civil court cannot preclude the magistrate court to take up the same issue with the same party. Res judicata is not applicable. That is the law.
Because different forums.
Yes, yes, madam. Now, in our case, my lord, he has cited this St. Mary's and others, my lord. Where is that legal prohibition that this Honorable Court cannot entertain that writ petition? Even, my lord, Supreme Court passed that order. Where is the legal prohibition that the order passed by this Honorable Court Division Bench and the Supreme Court? Where is that legal prohibition? Legal prohibition is not there. The basic contention at the first round of litigation also, I'll Lordship invite the attention of my Lordship to the compilation again. There, we filed the first writ petition saying that there is a pervasive control by the Assam Rifles. All the, my lord, the authorities, managing authorities, governing body and management are, my lord, men by the high-ranking officers of the authorities, include the state government. There is a pervasive control. And number two, you are performing public functions, imparting educations. My lord, they have taken the plea before the single bench that no, we are only a private society, provide private school, run by the Register Society, under the Society Registration Act. Therefore, writ is not mandated. We also took the plea that affiliation, after affiliation, one condition of the affiliation is that you have to pay the pay scale equivalent to the central government or the state government. That is also part. So primarily, my lord, there is a pervasive control. Number one, you are performing public duty. Single bench rejected our contention, upheld their contention. It is a private school. However, learned single bench herself, my Lady Judge, Justice Anima Hazarika, was not satisfied herself. Therefore, made an observation that I hope that ERPS school would adhere to the CPSE rules. Now, we took the matter to division bench, carried forward the same limb of arguments, and division bench upheld that contention and granted the reliefs. They traveled to Supreme Court, carried the same limb of contention. Supreme Court rejected. Now that, my lord, the compilation, my lord, I'll just show the certain ground taken by them. But it is the same ground they are taking, my friend is taking now. Therefore, they cannot take this ground again and again, man. I'll just lodge the grounds. Page number, my lord, 57, man. The grounds are available.
57 of?
57 of this big compilation. The loose compilation.
This
one more loose compilation. My lord, that is the one, I think.
This is the, you're referring to the school. I mean you're referring to this judgment?
Yes, right. Yes, that one. Page number 57.
It's not page marked. Huh?
Page initial is not there, my lord.
Not properly page marked. Yes, fine.
Ground started from page number 57.
Let me note down.
Now, I will come to the specific ground. My lord, we come to page number 60.
This is the
SLP filed by the RPS and the Union of India.
SLP,
yes,
not the order.
Not mine, my lord. SLP filed by them before Supreme Court against the division bench order.
Oh.
And the ground they have taken here, my lord.
Yes.
Lordship, may kindly come to page number 60, ground RS. Page number 60. Ground R in S, I'll show first, with Lordship permission. Ground R says they have taken because the schools are run by a governing body under the Director General of Assam Rifles. Now they say the Assam Rifles is not involved. There is the argument of the CJC now. It's contrary to the plea taken by them before Apex Court that yes, school is run by the governing body headed by the DG. How DG is not, my lord, necessary party here? Who is ex-office chairman of the society and other members of the management committee comprised of serving officers of the Assam Rifles and other representatives in accordance with bylaws, such. So that is one. Second is because the schools are run at no profit, no loss basis from the principal source of income to the schools is tuition fees collected from the students apart from occasional financial support from education funds subscribed on monthly basis by Jawans and other items, welfare funds of the Assam Rifles, which are non-public funds. So they have taken the same plea. My friend has taken the same plea in his affidavit in my today's petition also. Same plea he's taking, which was already taken before Supreme Court. And another point, my lord, I'll just come to, my lord, page number 63.
Yeah. '63.
63.
Yes.
Ground 80. My lord.
Yes.
Because school is not state within the meaning of Article 12 of the Constitution of India. My friend is arguing the same thing. 2-3 days argument confining on this. So how he can re-agitate this issue? My lord. Another ground, my lord, here's a ground, the AJ, the next page, my lord, 64. AJ. Because in Sadamla Sharma and others versus such, in others report in Sunset, it has been held by this court that unaided private schools over which the government has no administrative control are not state within the meaning of Article 12, and hence the obligation to pay the staff pay and allowances at par with state would not arise in respect of the private schools. The same argument. They are saying that it is a private school. ERPS school is a private school. Therefore, the High Court interference is not, was not right.
Yes, Mr. Sagrisu.
Yes.
Was an order passed in this case by the Supreme Court?
Yes. That is annexure is there. That, my lord, the SLP was dismissed by the Honorable Apex Court. I'll show, my lord.
SLP was dismissed.
But dismissed.
But
it was dismissed.
That does not necessarily mean that the merits was gone into.
My lord, the order is there. The order is the merit. I'll just show. Lordship, may kindly see the order. First case number 118, Sebastian. My lord.
Yes.
My lord. Page number 51. After marathon hearing, my lord, it was dismissed. Page number 51.
Of your petition?
Of my writ petition, my lord. Page number 51, my lord. Order was my 21/7/2015. And the order reads thus, my lord.
Yes.
With lordship permission, may I read, my lord. Having heard learned counsel appearing for the parties and perused the record, we do not find any reason to interfere with the impugned order dated 5/9/2012 passed by the High Court in writ appeal number such. according to the specialty petition is dismissed. Mr. Sansach, learned senior counsel appearing for the petitioner, fairly submits that the sufficient time may be given to the petitioner for compliance of the impugned order passed by the High Court in appeal. We therefore direct the petitioner to comply with the direction given by the division bench of the High Court while passing the impugned order and pay the arrears to the respondents within a period of 8 months. So on merits, my lord.
So this is substantial enough.
Yes, yes. On merits, my lord. After hearing all the parties, perusing the records, pleading up both the parties, Supreme Court dismissed it. Now the same ground lifted from there, my lord, re-agitate before this court. So therefore, earlier also I have submitted the decision that principle of res judicata comes into play.
So that the authority of that St. Mary's judgment will not apply.
It is not
Absolutely, my lord, I disagree with my lord.
I think, my lord, the hearing is the transfer matter I argue first. And before I reach to the amalgamation one, the next my friend started arguing that one. And I replied. Now last time he has finished his argument. Now if I sit down, this is the last privilege I'm getting, with lordship permission. If the respondent give reply again, then I'll come back again.
My lord, learned senior,
so there will be an unending
even
exercise.
After he has completed his, my lord, chances of argument, my lord, he has already finished with all these arguments, my lord.
We are giving reply.
No, he's refuting to you. You see,
yes,
now,
petitioner, appellant,
what has been raised, in your argument, is that decision of the St. Mary's Education.
Yes.
So
I must have a chance, my lord, also to reply.
He's retorting to that.
That would be, my lord,
yes,
an
ending
exercise.
Of course.
If lordship permits, then let him finish.
My learned senior has been continuing similar arguments, my lord.
In this case, similar matter is coming anytime. So
same thing, my lord.
Just one is time, just I just say. First leg of litigation, whatsoever I understand of this case, Your Lordship, this was regarding the pay scale of the petitioners. First case in the Supreme Court, it went to the Supreme Court. So this is not the list to this subject was decided because whatsoever in front of before this court. Earlier it was there, assembly given as per if the Central Pay Commission or whatsoever pay commission to be given the pay. And if it is admitted position, then this has come approved and reprobate. So once I have committed to make payment 10 rupees, I cannot say 9 rupees will be there. So in such situation, this went to the Supreme Court and it was decided, no, when it is given, the pay scale is given such and such, then it should be continued. So accordingly, pay was given and Supreme Court upheld. So here in this case at the moment, regarding the judicial matters come up, it is not particular the pay scale of the petitioners as given, as because if had it been done at point of time, this affidavit says, no, they cannot take up the matter, they should object on it, that's as per pay scale should not be given, whatsoever given. So this was the pay scale fixed commission is given and it is been upheld by this court as well as the Supreme Court. This was the matter thereof. And another aspect of matter, Your Lordship, he is saying that DJR is one of the member of the society. So anybody can be the member of the society. Society member, it is not restricted, and if it is given, it is not in the official capacity. Yes, he is pursuing the official capacity.
This is the problem with the my lord. When chance is given by my lord to argue, he said he has nothing to say. I am not necessary party. Now he is taking the leads. It is very confusing for me also
because now
to move forward.
Something else when earlier it has come up.
That is part of the plea. He refused not to file the affidavit also.
You have heard. You have heard his argument in the first instance.
Yes.
You have taken note of it, and the issue of the DJR being a part of the society has been raised, and it has been specifically submitted that because of the designation given there, it was assumed that it was in his official capacity, not otherwise. A, B and C or D can be member of any society for that matter in their personal capacity. He may be the Director General in his personal capacity, may be a member. But that is, that is the argument. As far as this is concerned, what Mr. Sangreso has raised a point is with regard to the previous case disposed of by the Supreme Court. You say that case was with regard to pay scale. Fine. That is the whole package. Within that, there's also the issue of Article 12.
Right. And this
So now that also, because being part of the whole package and having figured, in the grounds raised by the petitioner therein. So what happened is, when the matter was decided by Supreme Court, it would include every aspect of the matter, including the issue of Article 12. Anyway, that is beside the point. This court is hearing the party, so I will let him finish his submission. And Mr.
My lord,
Sankar,
let my learned senior finish his argument. Thereafter, my lord, in 5 minutes, my lord, I will reply. And thereafter, my lord,
that is not the practice followed by this honorable court. My lord, no. With due respect to my profound respect, my two learned friends, my lord, the petitioner has the first privilege to address this honorable court. Thereafter, the respondents give reply, and the petitioner or the appellant will have the last privilege to give a reply. There is no convention or the practices followed by this honorable court that the respondent's defendant will have the last privilege to argue the case and close the matter. Therefore, my lord, with highest respect to my two friends, if any points they miss out earlier and they want to address it, my lord, let them take the privilege. And I have read out this, the DG DG as a member, others. I spelled out earlier also. My learned CGC was very much there. He is supposed to give refuting that the contention. He said, I'm not the necessary party. I'm unnecessary drag on there. And now, my lord, when I give a reply to my friend, Mr. Singon, now, if all of them rise up again and that I'll give a reply to after Mr. Shungri finish, then I will say again that I have to give reply. That the practice is in my favor. Therefore, let my two friends, if they want to highlight certain points, let them do, and I'll give reply.
My lord,
let us at least follow that due
last
process.
Chance, my lord, to argue his matter, my lord.
But you have,
my lord,
Mr.
only
Sinkan,
2-3 points
you have already
I have done.
You have made an elaborate,
Right.
argument.
Only on one point, my lord, which my learned senior is talking of, because I will not have the last chance. So, my lord, I just want to point it out regarding the pervasive control of the members. My learned senior is saying that DG Assam Rifle, he is the member of the society. So only on that aspect, my lord, what I would like to say, if suppose Chief Minister of the state, my lord, now he becomes member of any of the organizations or any of the society, my lord, and then while enrolling him as a member, if the society records as a Chief Minister, whether that society will turn into a state, that is absolutely, my lord, it cannot be, my lord. That society, just because it has been wrongly recorded, it will not turn that society into a state, my lord. Similarly, my lord, here DG Assam Rifle, if he is recorded, whether in his private capacity he becomes a member in any of, because there is no bar, if he becomes member of any of the society, that itself will not make that society a state to come under Article 12, my lord. That is one point, my lord. And the another point, my lord, my learned senior, here in 217, my lord, they have been challenging the amalgamation process. And they are relying on an affidavit which was filed in earlier cases, my lord, where that affidavit was given by the ROS, Assam Rifle Welfare Education Society. That affidavit was filed in that proceeding, my lord, by the ROS, stating that they will follow the rules and they will not change the rules, rightly or wrongly, my lord. From one hand, they are challenging the ROS amalgamation, that there is no ROS because there is no procedure which was followed as per Societies Act. On the other hand, my lord, they are relying on an affidavit which was given by the ROS. This is another point. And as far as, my lord, the learned senior has pointed out this res judicata, my lord, I have relied on the Canara Bank judgment. In that case, my lord, we are not on the facts of that particular case. We are only on the principle which has been laid down by the Honorable Supreme Court. And the Honorable Supreme Court in that case has laid down that if the order of the court is erroneous, that order cannot be followed continuously on the ground of res judicata, that you cannot raise these questions. Therefore, my lord, we are not on the facts of that particular case. We are only on the principle which has been laid by the Honorable Supreme Court. And these are very recent judgments, my lord. And by these judgments, the earlier judgments, even which my learned senior has pointed out, that has been dismissed by the Honorable Supreme Court. After coming of this St. Mary's judgment, my lord, this has come in the year 2022. After this judgment, that judgment has already been overruled. By this judgment, my lord, what is the...
This is a larger bench.
Yeah, my lord. I have to find out, my lord. Now, this is a very recent judgment, my lord. By this judgment, it has been discussed what is the value of CBSE bylaws. And those previous cases, my lord, WA number 37, those cases which travel before the Supreme Court also on the basis of the CBSE bylaws, because bylaw provided that any person who is working in a CBSE affiliated schools, my lord, they have to be provided as per the central pay commissions or the state pay commissions. That was given in the CBSE bylaws, affiliation bylaws. Now, if CBSE affiliation bylaws says it has to be given, therefore, they have come before this court in earlier proceedings stating that I need this same CPC as per central pay commissions. Initially, the matter was dismissed by the court. Thereafter, they went for appeal, my lord, writ appeal. Writ appeal decided in their favor. Ultimately, matter went to the Supreme Court. In that case, there was no discussion as regard to the bylaws of the CBSE, my lord. What is the persuasive value of these bylaws? But in a very recent judgment, St. Mary's case, my lord, the Honorable Supreme Court has decided only on this aspect. What is the persuasive value of the CBSE bylaws? Because this CBSE is not a statutory body from under statute, it's just a society. Therefore, my lord, even if there is any violation, it does not create any rights on the petitioners to challenge under Article 226. This is what the Honorable Supreme Court has said in this recent judgment, my lord. This is binding on this court as well. And if we follow this judgment, my lord, this earlier judgment is wrong. And the principle of res judicata, my lord, as has been laid down by the Honorable Supreme Court in Canara Bank case, my lord, erroneous judgment, my lord, cannot be allowed to be followed. And it cannot be continued only on the ground of res judicata, my lord. This is an exception, clear exception, my lord. And my lord, this is what I had to submit, my lord. I do not want to continue any further, my lord. I have already done on the last occasions, my lord, all my submissions. Obligement.
To continue.
Well, the jurisdiction matter, my friend has lastly asserted that on erroneous ground, the erroneous decision cannot be continued on the plea of res judicata. And the Honorable Court says that what are the erroneous decision of the court? Erroneous decision of the court is that when there is a legal prohibition and yet court pass an order that is erroneous, on the application of res judicata, it is not applicable. It cannot be continued. Number two, erroneous decision rendered by a court without any jurisdiction, like I say, civil court, rendering a judgment in the criminal matters, or criminal court rendering a judgment in the civil matters, is our erroneous decision. Therefore, this doesn't, my lord, attract res judicata. There is two exceptions spelled out by the Honorable Court. Now, in our case, my lord, therefore I say, in our case, St. Mary's case I've gone through, there was no pervasive control. You see, my lord, no central government or state government pervasive control. The only contention raised by the petitioner in St. Mary's case is that since it is affiliated to the CBSE, read is maintainable. Therefore, the Honorable Court say that CBSE is neither a statutory body. The rule made by the CBSE doesn't have a statutory taste also. So whenever the violation of the CBSE rule is there, party can go to civil court also with regard affiliation. And in that case, my lord, St. Mary's case is a case of termination of, my lord, the non-teaching staffs of the St. Mary's schools. My lord, that is the case. My lord, in my case, how it applies to my case, my lord, till now it is difficult for me to appreciate this contention. My lord, the case is quite distinguishable. The Supreme Court cited my friend is not applicable. My lord, my friend is in short saying that judgment rendered by this court and order by apex court is erroneous in nature. Erroneous. On what ground, my lord? It is not the case that the judgment was delivered by without jurisdiction. Therefore, my lord, this issue cannot be, my lord, racked up by the party again and again. Now today, my lord, in that case, the pay fixation case, equivalent case, they say, Supreme Court says that you are a state. You fall within the meaning of Article 12. Made the ends up there, they came back to Shillong, complied everything. In other cases, I have cited, this Honorable Court has interfered. Some cases, they complied with. Now, when I come for transfer or amalgamation, they cannot say that, no, I'm a private person. But once the identity of the school is determined by the court of law, having a competent jurisdiction, the identity remains the same. They can fight on merits. One merit is, as my lord that pointed out by them, I have no locus with regard to the amalgamation. Whether the amalgamation process is legal or illegal, since you are not a member, I have no locus. They are contesting on merits, not identity of the ARPS. My lord. I would understand, my lord. Therefore, this citation given by my friend is not applicable. And if that is applicable, my lord, all the judgment, therefore, I cited in 2013 matter, the decisions rendered by the court, even assuming that it is incorrect earlier, it cannot be altered. It is very, very clear. Principle of res judicata is there. Otherwise, the Supreme Court says that, my lord, today, Lordship passed one order. After 2 years, somebody come and question. It is, my lord, it is said that Lordship order today is illegal and gone again. Then all the issues Lordship is considering today will be revived again. So there will be unending litigations that affects the public policy. Therefore, there should be an end of litigation. Therefore, with regard to the maintainability of writ petition against the ARPS, it is ended. It is ended. What is available to the ARPS is that they can contest on merits. On merits. On merits. And my friend last, he said that TG was wrongly mentioned in the minors. It is not applicable. It is not a question that TG name is wrongly mentioned. It is not the case. The CM is, has gone to one society, organization in the evening, my lord, sit together, and attendance of Honorable Comrade Sangma, Chief Minister, is reflected. Then the society converted into a state. That is not the contention. The rule here clearly spelled out under the Society Registration Act, Memorandum of Association, and the rules and regulations framed under that Article of Association. They clearly spell out that TG is the head. It is not Mr. Shukla. They are right. Mr. Shukla, Mr. Bravin, my lord, Mr. Kumar can be a party, can be a member of any persons under service rule, so long as service rule provides. But it is not the case that Mr. Shukla came and he's the head of the ARPS governing body. It is the DG of the organization. It is the brigadier. Therefore, the distinguishing, it is easily discernible. Therefore, they are representing in the capacity of a organization, the chair he occupied. It is not, they are not representing in the capacity of an individual citizen. Now, Secretary of the Education is the party. My lord. The same law applies. My lord. Secretary of the Education, here we are talking about not the citizen, natural citizens. It talks about the state representation. My lord. The Chief Secretary of the State of Meghalaya is today, my lord, Mr. DP Walang. When we talk about the Chief Secretary, we're not talking about DP Walang. It is the state. But if the society say that DP Walang can be the member of the society, then forget about the state entity. He's representing individually. Therefore, the moment they say the entire governing body, managing committee, spearheaded by the top officers of the army generals, therefore they cannot say that it is a private school. Therefore, Supreme Court denied. Learned Division Bench has denied that argument. Therefore, they cannot drag up this issue again and again. So, with regard to that one, my lord, I will not take lordship further time. And my lord, the issue that with regard to the affidavit, my lord, I'll just point out the affidavit filed by my friend in the Sebastian case. But in the Sebastian case writ petition, my lord, may I come to the transfer matter? 119. My lord, it is a long drawn hearing. I'm grateful for patient hearing. But this issue, my lord, since head jurisdiction issue was not raised by my friend, matter perhaps would have been concluded. But that issue was raised, therefore,
yes, because
my
the issue
lord has given.
Since you see the initial challenge to maintainability was raised, so that has to be handled first.
Lordship, because of the lordship, precious time is giving to all of us. Now, may I just come to that, my lord, order passed by this honorable court, page number 53.
Yes.
Well, the DGO has made to close down the school. That time we also challenge.
Yes.
And this is the order passed by the court in that case. It's a very short order. May I just read out, my lord? My lord. It says, my lord, upon take up this matter for admission hearing.
Lordship, it's because I'm not having any other throat to say anything. May I take leave?
Yes, yes.
Because my person is complete, so it may take leave.
Yes, you go.
There's nothing to reply.
You have nothing to reply. So.
I have to go to the doctor again.
Yes, yes, go. By being here, you might prolong the proceedings. Please. Yes, please. Yes.
My lord, it is a very short order, page number 53.
Yes.
Upon taking up this matter for admission hearing after the filing of the amended petition, the counsel for the petitioner has attempted to submit that although the issues have already largely been settled, but in the face of the impugned order is a closure order, whereby Assam Rifles Public School at that court Shillong was proposed to be closed, and the resolution dated sunset whereby management of the school was proposed to be taken over by Assam Rifles Welfare Education Society. The petitioner, staff, and teachers of the school have the apprehension of likely prejudice in their service and the condition of their service. At that time, my lord, also they have the society amalgamation was already taken over. Now, in response, Mr. K. Sansar, learned counsel appearing for the respondent number 1, such, yes, has candidly submitted that with the proceeding that have been placed pursuant to and in conformity with the court's order of this court, and when the matter relating to service condition has attained finality, with the decision of this court and the apex court, the earlier notice of proposed closure has already been lost its relevance and is redundant, and the respondents could neither change nor do they propose to alter, adversely order the existing service condition of the concerned employees. During the course of submission, learned counsels and such also place on record the affidavits and such. Now, therefore, my lord, before this order court, they file an affidavit, swear the affidavit, and make a submission that we will not change the service condition of the employees. Now, I'm subjected to face the suitability test every year. They are altering the service condition. At that point of time, transfer was not the issue. Transfer is not part of the service condition. Even appointment letter, contract service on the rules and regulation, now they are introducing this. This has really adversely affected. So this is, in fact, my lord, is a violation of the undertaking or the order passed by this honorable court. Now, therefore, with regard to amalgamation, I must be very frank, my lord. The result of the amalgamation, I am concerned with. My lord. Amalgamation, my lord, it is quite reasonable that it is illegal. But since I am not a member, that is the soul and heart of the argument of my two friends. Since I am not a member of the society, I have no business to question the fairness of the amalgamation process. My lord, I understood my limitation there. My lord. But here I am concerned with the results. What they do after amalgamation. I would consider that, my lord, if the learned friend, ERPS, say that, yes, we will not apply that amendment. Suitability test, transfer, we will not apply to you. But we will apply this amendment to our new employees that may be appointed in future. We would understand.
So you see, what happened is now, as regard the amalgamation, if you are, stopped from raising any issue in that matter, so we take it that the amalgamation, whether rightly or wrongly, has been affected. Now, subsequently, in view of the amalgamated position, certain rules or regulation or directions have been passed.
Yes.
You agree by that?
Yes, we agree.
Being affected because now you have become part of the, the faculty, or part of the the organization as such. So, have you raised any specific or other separate, objection on that?
Yes, we have taken the complete pleadings in that McCartney case, Lordship, kindly see. We challenge all the amalgamation decision and the
yes, as far as
amendment also.
Challenge to amalgamation may be, you may not be, entitled to it.
That is the contention. Assuming, my lord, that I have no business to question that amalgamation process. Second phase of the amalgamation action, I am agree with that.
Okay.
I am agree with it. Therefore, if learned, my lord, that and also the amendment doesn't say it has a retrospective effect. It has a prospective effect. Those who have already appointed, normally, my lord, it will not apply to them. It will apply to the coming, my lord, coming employees. So, with fairness, my lord, if my learned two friends say, especially ARPS, say that, yes, we will not apply this amendment, suitability test and transfer to the existing employees, since we have given undertaking before the High Court that we will never introduce any adverse alteration of the service condition. My lord, we will not press for setting aside the amendments, introduction of new regulations. My lord, that serves my interests. It may apply to the future employees, my lord. But they cannot say that, no, they have given one undertaking before the High Court and they go back to light court and introduce it and apply to me and try to remove me. That is unfair, madam. That is unfair, madam. That is the grievance of the writ petitioners. Therefore, the amendment, my lord, the amendment introduced by the ERPS, so-called the Welfare Society now, it is illegal, my lord. The undertaking given by them, that time also, it was Arwis. My friend has pointed out that it was Arwis. And even this present affidavit also swear by the Arwis. It was not filed by the ERPS in that petition earlier, closing petition also. Affidavit was swear by the Arwis, governing body, the governing council. That we will not change. We have taken over the ERPS society and we will continue to run it, but we will not change a service condition. Now, therefore, the same parties who are here, earlier also they are there, my lord. They cannot take the dual stands, my lord. Therefore, the action deserves to be, my lord, set aside in court. And since, my lord, the other judgment I placed earlier, what I propose with lordship permission is a lengthy hearing lordship allow us to advance. And therefore, may I suggest that the bullet points of the arguments from all the parties may be allowed to, my lord, furnish it, my lord, supply to this honorable court, along with the judgment if necessary.
That will be that will be helpful,
my lord. Otherwise, the last point, my lord, the introduction of the amendment transfer, sending to another person, I relied that Supreme Court order and that Calcutta judgment. But I just SSC lordship suggested me last time that I should not rely on the canon, but the SSC online. We have taken that. I'll supply.
That you can indicate in your written argument.
My lord. And the last point, my lord, the amendment made by the friend, that affidavit. If it filed by my friend, my lord, in the McCartney case 217, my lord, he has referred to a number of judgments, my lord, regarding jurisdictions, including the order passed by this honorable court in NIPCO matter, which is stated by the honorable apex court till today. He is relying on that, my lord. I'll just annex that that copy also, my lord. So I will, my lord, this is the order. In certain paragraph, he has referred to the order passed by this court regarding NEPO matter, transfer matter. One of the best courts say that first order as of now. But my friend is relying, therefore, to avoid that confusion, my lord, I'm applying, I furnishing this judgment, my lord. In the meanwhile, until the next date, operation and effect of the impugned order shall remain stay, and therefore the earlier orders and such passed by the learned single bench in WPC shall remain in operation. That was the interim order passed by the single bench, my lord. So, my lord, to avoid, otherwise, if lordship rely on that, which is stated by Supreme Court, that would create confusion in the near litigation. Therefore, I want to clarify that.
Set aside, my lord. That is only been stayed.
If it is stayed, my lord, it is not alive. No one can rely on that.
Stay means stay. He stays put.
It has no life. It has no life. It has yet to see the light of the day.
So indicate this in your.
But we will indicate that one. We'll indicate. So within a week, my lord, we will be ready to, my lord, submit the from my side. Yes.
So all the parties are requested to file. Because you see why, because of the the length of argument that we have gone through, it would be clear. It would be better if you put it in its own perspective, even the state also for that matter, whatever you have stated, so that there will not be any confusion later on.
My lord, earlier I filed also, my lord. My lord, I'll take that back and then I'll file a fresh one.
Please
Include new points also, my lord, which we have given after.
Whatever is on record, whatever you give, the latest one will be considered.
My lord.
Only one point with lordship permissions. Regarding that point that the amendment will not applicable to the existing employees. That if my friend wants to take instruction with regard to that, in that case, I will not press those.
My lord, that what my learned senior has.
If he insists for that,
I will definitely take instruction on that point.
Because that would be, would be material. Because that in fact, that would be the crux of the matter.
My lord. But only one thing, my lord, I would like to point out what my learned senior has said, that they have given in writing to the court that they will not change. It's just like saying the member of Legislative Assembly giving in writing to somebody saying that we will not make law, we will not amend law. Does it make any sense?
No, this is in a very in a different context altogether.
Right.
Different context.
Right.
And that is not a direction of this.
It is not. As if I can understand correctly, what Mr. Sangreso has said, this is only with regard to the prospective and retrospective effect.
Right.
So perhaps what you mean is that you will abide by your commitment before the court and no retrospective action to be taken, prospectively perhaps.
Yes. Let my friend take instruction with regard to that aspect.
I'll definitely take
instruction. You come back within 1 week?
My lord, I will file a written argument in the meantime also.
Heard learned counsel for the parties. The argument is concluded. However, however, with regard to an order dated 10/8/2016 passed by a division bench of this court or is it not division bench, passed by this court in writ petition number 100 of 2016, particularly as regard the assurance given by the respondent ERPS before this court relating to the terms of relating to the condition of service vis-a-vis transfer of the faculty and employees. The learned counsel for the respondent RPS has submitted that he may be allowed to seek instruction, latest instruction in this regard. Same is allowed. In the meantime, as prayed for by the parties, the written argument is allowed to be filed within the next date fix. It's allowed to be filed. This is matter after 1 week.
I do.
Item number 14.
Yes. Who's to submit?
Lordship, I apologize. Lordship, I'm praying for an adjournment as the Advocate General, he's on legs before the apex court, Lordship. Before the state respondents, Lordship.
I think Mr. Dr. Musga, who your colleague will submit or you will submit?
My lord.
You're supposed to
My lord,
file.
the state is supposed to reply, my lord. And they've taken a lot of time, my lord. My lord, what is happening? He will also recollect, my lord. By the interim order, my lord, constructions were allowed by the order passed by this honorable court, my lord. Justice Moore at that point of time, my lord. That was under the belief that the matter will be decided soon. And it appears that this is a tactical delay, my lord, done by the state, my lord, to ensure that while the matter is pending, they delay it and the construction is completed, my lord. That will lead to an irreversible situation, my lord. My lord, if AG has some difficulty today, there are 4 additional AGs, my lord, now. He can entrust the case to somebody else, or if he really wants to do the matter, my lord, maybe on Monday, my lord, Monday or Tuesday. But today I'll not oppose that much, my lord. But it cannot be beyond that.
Monday, I think we'll fix it after a week.
Tuesday, my lord.
Perhaps
it can be on Tuesday, my lord. My lord, normally I would not have objected, my lord. Only difficulty, my lord. The construction is in full swing, my lord.
Mr. Dr. Muzika, if I recall correctly, your senior colleague had made a mention that the written synopsis or argument of the argument will be fine.
My lord.
Has that been done?
That is ready with us, my lord. But the state is supposed to reply, my lord. They should reply. We'll file it in.
Fine. Mention has been made on behalf of the learned Advocate General, who is said to be indisposed and could not appear before this court today on behalf of the state respondent. On consideration of the prayer made, the same is allowed. This matter will now be heard
on Tuesday, madam.
Not on Tuesday. We'll have it.
Wednesday, madam.
Monday.
Lordship, that's April calendar. I think it will be 4th or 5th would be more appropriate.
Not 4th. Perhaps on 4th.
3rd, madam.
We'll have it on the 9th then. 9, I think, slightly free.
Madam, what is happening, madam? The construction is going on, madam, and they're delaying the matter, madam.
Please, Lordship. Lordship, since next week would be the last week working week means due, but the 9th would be more convenient to the AG would be here for the whole week, Lordship.
Mr. Muzika.
My lord, but no, my lord, only one thing, my lord. Subject to condition that no further adjournment will be sought by them, my lord.
Please.
That may kindly be reflected, my lord. That may kindly be reflected, my lord.
This is matter on 9 as prayed for. 9.
My lord, no further adjournment will be sought, my lord.
Dr. Muzika, if I do that, you see, more often than not, like I said, they will come with some.
My lord, at least
some genuine. I'm not saying I'm not saying otherwise, but they may come with some.
My lord, kindly appreciate, my lord, the expenditure of 100 crore plus is being done on the basis of the interim order by this honorable court, my lord. This should be fair to us also, my lord.
If
the state is totally unfair, my lord,
if in the final analysis you are you are entitled to, then adequate compensation will be given to you.
My lord, that interim order is already there, my lord. But further delay, my lord, and this is tactical delay by the state, my lord. It is very unfortunate, but I can say that, my lord, this is a tactical delay caused by the state, my lord. My lord, only that much observation, my lord, that will at least put some pressure on them, my lord, to be ready on the state, my lord.
No further adjournment will be allowed. No further adjournment will be allowed. Fine.
To my knowledge, I think 9th would be the last working day in Supreme Court, Lordship.
No, 9.
My lord, the AG has taken up the matter, my lord.
9 is not the last working day. 22nd, in fact, will be. Perhaps I may be wrong.
I'm not mistaken. Sorry.
We'll take it up. Like husband, you have a number. You see, a battery of lawyers with you. You can make arrangement accordingly.
Or else they can stop the construction, my lord, and they can delay the matter for another 1 year. I have no problem, my lord. Yeah, they have to be fair, my lord. They cannot just laugh at things, my lord.
We'll look into that. We'll look into that.
My lord. I'm deeply obliged.
Item number 17.
May I please your lordship, on the last date, the senior counsel submission that the respondent has not present has not signed the agreement. So we are still waiting for the instruction from them. So kindly adjourn the matter for a month.
I know why this matter is. Who you are praying for?
From the appellant side.
Where's the respondent? Yes, Mr. General is not here. Learned counsel for the appellant has submitted that though this court has indicated that the said compromise, a deed of compromise or settlement is to be finalized by the parties and to be filed before this court, the same could not be done so. Same could not be done so. In fact, no representation is made on behalf of the respondent to the. Accordingly, the matter is adjourned and the same is listed after 2 weeks.
Item number 19.
This item will not keep my attention, but I cannot file the written argument. Otherwise, I'll rely on my affidavit, because we have nothing much to say.
Who you are for the
petitioner?
Have you filed your?
Yes, we have filed.
Written argument you filed?
Yes.
And? Okay, we are waiting for you, but your role is very important here, because that is with regard to the approval of how you have come about it, on what basis.
Then I'll file it. Of course, my friend has given me a copy of the written argument now.
Please do that within a week.
Well,
otherwise, matter will be heard or will be disposed of accordingly. Learned Mr. K.P. Bhattacharjee, Learned GA appearing for the state respondent, has submitted that the written argument on behalf of the state respondent could not be filed today and has sought for some more time for the same to be filed. On consideration of the submission made, the same is allowed. List this matter up to 1 week. But be sure, like I said, if you can't do it, then you file your affidavit.
Well, affidavit.
We'll see. We rely on that one.